Hello students. In today's lecture we will be discussing about the appeals, penalties, offences and prosecutions. So the different types of provisions have been given in the Income Tax Act regarding the appeals, penalties, offences and prosecutions, and these provisions we will be discussing in this lecture. Appeals. An appeal is a petition against the order of the assessing officer. For example, the assessing officer has passed any order, but the assessee is not satisfied with that order. So he can appeal against that order. He is having the right to appeal against that order. So that appeal can be made to the commissioner appeal. That is, the income tax commissioner को अपील की जा सकती है. That appeal has to be made within the 30 days of the order passing of the order by the assessing officer. And if the appeal is made later than on the expiry of 30 days, even then the commissioner can accept that appeal if he is of the opinion that it can be accepted, and some necessary fees will have to be deposited by the assessee for making appeal against the income tax commissioner. Then if some order is passed by the commissioner appeals of income tax and the assessee is not satisfied with that order, then in that case the assessee is having the right to file an appeal in the appellate tribunal. That appeal can be filed against the order of the commissioner appeals. Again, there are certain formalities, certain fees is to be deposited, certain procedure is to be followed for that purpose. After following those procedures and depositing certain fees, that appeal can be made by the assessing officer to the appellate tribunal against the commissioner appeals of income tax. The appellate tribunal is created by the central government, and the powers are given by the central government to the appellate tribunal. And this tribunal may have different branches and different types of cases related to income tax. They are, we can say, considered by the appellate tribunal. And appellate tribunal will have the same powers as are the powers which are enjoyed by the income tax authorities. Then, against the order of the appellate tribunal, the appeal can be made to the High Court. That is, again, if the assessee is not satisfied with the order given by the appellate tribunal, then he can file the appeal against the order of appellate tribunal to the High Court. So High Court, minimum 2 judges must be there. 2 or more than 2 judges, a bench of 2 or more than 2 judges will be considering that appeal, and the final decision in the appeal will be decided by the majority of the judges, and certain fees which has to be deposited by the assessee for making appeal, that is decided by the High Court. And then against the order of the High Court, the appeal can be made to the Supreme Court. So if an appeal is made to the Supreme Court, then against the judgment of the High Court, then the Supreme Court, after hearing the case, shall decide the question of law. Means what is to be done and what decision is to be given, that is given by the Supreme Court, and what will be the cost of that appeal, that will be decided by the Supreme Court. Next is the penalties. So in Income Tax Act, there is a provision of certain penalties also. Penalties are imposed on the assessees if the assessee fails to comply with the provisions of the Income Tax Act. That is, certain things, certain rules and regulations which have been given in the Income Tax Act, but the assessee fails to comply with those provisions, then in that case certain penalties can be imposed on the assessee. And this is the complete list which can be seen for various types of offenses, we can say for various types of defaults, different types of penalties have been kept in the Income Tax Act, and those penalties will be imposed on the defaulting assessee. For example, underreporting of income 50% of the amount of tax payable on underreported income, and misreporting of income 200% of the amount of tax payable on underreported income. Failure to keep, maintain, etc. books of accounts, documents, etc. 25,000 rupees will be paid as a penalty. Then, so you can see this list. This is the exhaustive list. This includes all the sections which are given in the Income Tax Act, on which different types of penalties have been given. Next is offences and prosecutions. So offences means if some offence is done by the assessee, then in that case there are provisions of prosecution also. That is, the assessee can be prosecuted, means some type of fine may be charged from the assessee, some imprisonment may be there. So different sections are there. For example, we start with section 275A, contravention of order on section 132 subsection 3, not to remove or part with any books or article. Rule is not to remove any part or books of article, but if the assessee is a defaulter of this, then he may be charged a fine, or he may be imprisoned for up to a period of 2 years. Failure to provide the facility to inspect books of accounts. If the assessing officer wants to inspect the books of accounts, it is the we can say obligation. The assessee is under an obligation. It is the duty of the assessee to provide him, the assessing officer, with the books of accounts. And if he fails to do so, this is an offence, and this may be again a fine may be charged from the assessee, and an imprisonment of 2 years may be imposed on him. Similarly, removal, concealment, transfer, etc. of property to draw tax recovery, then fine and imprisonment up to 2 years. So this is the complete list, where the different types of offences, if done by the assessee, then different types of fines and different types of prosecutions, imprisonments and punishments, etc. are there for the assessees. Thank you.